The Honorable, the Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Thank you, Madam Clerk. The first case is State versus Corbett and Martins. We'll hear from the appellant.
Thank you. May it please the court. I'm Jonathan Babb with the Attorney General's Office representing the state. I'd like to reserve 5 minutes for rebuttal. Late on August 2nd, or in the early morning hours of August 3rd, Jason Corbett was beaten to death by defendants using a baseball bat, metal baseball bat, and a paving stone. Cause of death was blunt force head trauma. There were 10 different impact areas to Jason's head, 2 of which were complex, meaning it was more than one blow at that impact site. These 2 complex impact sites were at the back of Jason's head. After EMS arrived, when a paramedic tried to lift Jason's chin to intubate him, all the fingers on his hand went into Jason's skull. As they treated Jason, one paramedic asked another, "How long did you say they waited to call 911? She asked because she testified his body felt cool. Paramedics noticed there was gelled blood in Jason's eye socket and some blood on his body had dried. Officers at the scene had noticed some blood on the wall that was dry. As for defendants, they were at the scene when EMS and law enforcement arrived. Testimony from the officers at the scene and photographs of defendants taken later that morning at the Sheriff's Department did not show any injuries to defendants. Jason's children, Jack and Sarah, were sound asleep upstairs during this incident and had to be awakened by officers and carried downstairs out of the house. The state's expert in bloodstain analysis testified that the blood on the wall showed a descending succession of impacts, and the splatters on the boxer shorts worn by defendant Martins were consistent with the wear of the shorts being close to the source of the splattered blood and above the source of the splattered blood, with the conclusion that the source of the impact splatters was most likely Jason's head while it was close to the floor in the bedroom. Defendant Martins testified that during the night he woke up, heard sounds above him, as well as a scream or loud voices. The former FBI agent said he did not think to call 911, but instead grabbed the metal baseball bat that he testified he brought to give to his grandson, but did not give it to him the day he arrived and kept it until that night. And he went upstairs. Defendant Martins testified he saw Jason choking defendant Corbett, advanced on Jason, and hit him in the head with the bat. Martins testified afterward, from that point, there was a life or death struggle, including Jason taking control of the bat from him at one point, and defendant Corbett being held in a chokehold so tight she was just dead weight. Neither defendant had any injuries, not minor injuries, 0 injuries. Only defendant Martins testified. Defendant Corbett did not testify at trial. The jury was instructed on self-defense and the aggressor doctrine as to defendant Martins. No aggressor instruction was given in regards to Molly Corbett. Each of the defendants was convicted of second-degree murder. The majority below overturned the trial court's rulings and the jury's verdict, holding that evidentiary errors were so prejudicial as to merit a new trial for defendants. For the reasons argued in the state's brief, the majority was incorrect as to both the existence of error and any prejudice resulting therefrom. The dissenting judge was correct when she held that defendants received a fair trial free from prejudicial error. This court should reverse the majority's opinion and affirm the jury's verdict. Turning first to the first issue in the state's brief to this court, it was not prejudicial error for the trial court to exclude the statements of Jason's children, Jack and Sarah, their interview statements at trial. Defendants sought pre-trial to have hearsay statements admitted of Jack and Sarah from interviews with DSS and interviews with Dragonfly House, a children's advocacy center. There was a 2-day hearing, pre-trial. At the end of that 2-day hearing, trial court did not make a ruling, but reserve ruling until the trial. At trial, after Defendant Martins testified and a character witness for Defendant Martins testified, trial court ruled the statements were not admissible under 803 sub 4 and 803 sub 24, the medical diagnosis exception and the residual exception. Looking first at the 803.4 statements for the purpose of medical diagnosis or treatment. Defendants moved pre-trial under this rule of evidence, seeking to get the Dragonfly House interviews admitted into evidence. Under Rule 804, statements made for the purposes of medical treatment are exceptions to the rule against hearsay. They're not excluded by the hearsay rule. But this court has held in State v. Hennett that, quote, Rule 803.4 requires a two-part inquiry. One, whether the declarant's statements were made for the purposes of medical diagnosis or treatment, and two, whether the declarant's statements were reasonably pertinent to diagnosis or treatment. And that was in Hennett at 284. The trial court found that the children's statements did not meet the first prong of Hennett, as they were not intended to obtain a medical diagnosis or treatment, and that part of the order is on record page 636. Consistent with the trial court, the dissent below found that the objective circumstances of the record surrounding each child's interview do not indicate that Sarah and Jack understood the purpose of the interview was to gain information from them for their medical diagnosis or treatment.
Mr. Babb.
Yes, sir.
I hate to interrupt someone who's in mid-flow, but if I don't, I'm going to might lose track of where we were. Is it your contention that the finding that you just alluded to is a finding of fact for purposes of Rule 104 of the Rules of Evidence?
I believe it is, Your Honor. I will admit that it's a little, it's a little confusing. I can't point as firmly as I'd like on that, but yes, I believe it is a finding of fact. But even if this court were to find its conclusion of law, it would not be error. But yes, Your Honor, is the state's contention that is a finding.
That goes to the question that I've got both for this and for the residual hearsay issues, which is what exactly is the nature of the inquiry that we're supposed to conduct here? Are we supposed to determine, one, whether those findings have evidentiary support, and then therefore determine if they do or don't what the outcome ought to be, or are we supposed to be making some kind of determination on our own as to whether the record before the trial court suffice to support the determinations that are required to admit or exclude both the alleged statements for medical diagnosis and treatment and the residual hearsay?
Well, Your Honor, on the residual exception, that's an abuse of discretion standard, and I think that's a little clearer guidance for the court. I will state that in Hennett, it doesn't state that this is an abuse of discretion standard for the court, and so I think I think this court is bound by findings of fact, but then have to determine if the findings of fact support the conclusion that it was not allowed by Rule 803.4.
Well, let's say for purposes of discussion with respect to the medical diagnosis issue, if we were to determine hypothetically that the trial court's finding with respect to the issue of what was the intent of the children at the time that they made the statements, and we were to find that there was evidence that the children intended something other than medical diagnosis and treatment, does that end the inquiry, or do we have to look at it anew to determine whether we agree with that determination?
Your Honor, I'm sorry, could you ask that question again? I may have lost it.
I doubt I can do it that badly, but I'll take a crack at it. If we've got a finding that essentially the statements were not made for the intent of obtaining medical diagnosis or treatment by the trial court, and I'm just using finding because I don't have a better word. Is the question before us whether that finding is supported by the evidence, or is the question before us whether in an independent review of the record we agree or disagree with that determination?
I think this court looks to see if that finding is supported by the record. But in this case, either path the court would take would lead to the same destination. As the record here is, when asked why he was at Dragonfly House, Jack responded, it's because people are trying to take him away from his mom. And by mom, he means Molly Corbett. Doesn't mean his birth mother. She died years previously from an asthma attack. But Jack responded, people are trying to take him from his mom. When asked who told him that, he responded, my mom. And Sarah, when asked why she was there, she said, because my dad died. So, and the children, their statements themselves show that the statements were not made for the purpose of medical treatment. It was concerned about custody on the Dragonfly House on August 6th. So given the record, the court properly held that the exception of 8034 did not apply. And this court said in Hennett that the proponent of the rule 8034 testimony must affirmatively establish declarant had the requisite intent. And here the children's statements alone show they didn't have it, the statement itself internally. However, you also have the additional evidence of, I'm sorry.
Can I stop you for a second? I just have a question about that. Is it your argument that the children's understanding or purpose themselves subjectively about the statements is dispositive on the purpose of the statements?
Well, reading this court's opinion in Hennett, Your Honor, the motivation of the declarant seems to be what the court was looking at. And so, at some point, there can be problems where the children were, say, younger than Jack and Sarah were. But here, it isn't the absence of an understanding. It's their understanding was they were here because someone's trying to take them away from mom. So I think that makes it pretty clear to the court what they thought they were there for and what they believe was going on. And so I do think, given this court's looking at the intent of the declarant that this court refers to in Hennett, I think that does show that the first prong is not met because of the children's statements. And that's only buttressed by the subsequent recantation in their diaries and also Jack's Skype interview in 2016, where he says that he wasn't truthful in those statements earlier, the recanted statements to Dragonfly House and DSS, because he was scared of defendant. Now, even if this court says that, I'm sorry, Your Honor.
I was just going to ask if the evidence showed that the inquiry for the questioners was to determine whether the children had been subject to abuse and needed some sort of mental health treatment. Is it reasonable to end the inquiry with their subjective belief of what they said about the purpose of the statements?
Well, Your Honor, I don't even think you have to reach that here because you have the children's stated intent, plus you have the surrounding circumstances, including the recantation of the statements in 2016.
But don't we also say in Hennett that it's hard to ascertain what the understandings may be of child declarants? So to that extent, we have to, as a court, take that with somewhat of a grain of salt, don't we?
I think you have to look at all the circumstances surrounding Your Honor, yes, because what yourself and Justice Hudson are getting to is, with children, their understanding. But here, the state submits that the children's understanding was made clear by their statements at Dragonfly House and also the recantation in 2016, which, even if this court says, well, that's not admissible at trial, it was proper under Rule 104A for the trial court to consider in determining the admission of the Dragonfly House statements. Now,
If I can just follow up on that, if we are, and as I understand, if we are looking at all of the surrounding circumstances, aren't there other circumstances here, including what the children were told before the interview, the fact that after the interview they saw the doctor, the fact that they actually were diagnosed as children who needed medical services because they were traumatized by domestic violence? Aren't those also circumstances we should consider in assessing whether these statements were sufficiently reliable because they were made for the purpose of a medical diagnosis?
yes, Your Honor, the court should consider all the evidence, including the evidence you mentioned. However, I believe the records, and this is in the state's brief, what the determination was that Sarah did not witness domestic violence. But, and of course, at the pretrial hearing, they don't say exactly, they don't determine who was the offender necessarily. But yes, Your Honor, you do have to look at everything. But given this particular sort of, I don't want to say it's unique, but it's a little out of the ordinary circumstance where the statements are specifically recanted. I think, Your Honor, the court has to look at that as well. And that is also true with the residual exception. The trial court found that the statements were not trustworthy in their record because the children were not being honest, and the court looked at the recantation on that, the 2016 recanting of the earlier statements, and that's under an abuse of discretion standard, clearly, as in State v. Valentine and State v. Smith made clear. And so I think, Your Honor, that is even less of a question in doubt, because surely there was evidence in the record that shows that the trial court's decision wasn't manifestly unsupported by reason. But when we're looking at both 8034 and 80324, those do not mean the statements are admissible. It just means they're not barred by the hearsay statement. The children's statements are also, the defendants have to show that they would be admissible. And here, many of the statements are double hearsay. Where
Mr. Babb, when we get to this point, let's focus on the things that at least I understand your colleagues to be saying they're really trying to get admitted, which were evidence as to why the paver was in the bedroom. Secondly, about the incident involving the daughters being woken up in the middle of the night. And thirdly, prior instances of alleged domestic violence upon which they claim to have personal knowledge about. Why are those three items, in your view, not otherwise admissible, assuming we get past the hearsay rule?
Well, yes, sir. First, statements of prior alleged incidents of domestic violence. Some of those are followed or internally inconsistent in the children's statements to DSS and to Dragonfly House, in terms of when you read one, it may appear that it's not totally clear, but it may appear that Jack or Sarah were witnessed the events, of the night of the murder, but they didn't, obviously, because they were.
I don't mean to focus the argument a little bit. I don't understand your colleagues to be arguing that the statements that they made describing what happened on the night of the events, with Correct. The exception of Sarah's waking up, that they're not trying to obtain admission of that evidence. Let's focus on what they're trying to obtain admission of.
Well, the children's statements are not admissible. The recanted statements are not admissible to show that the victim was the aggressor. This court said in State v. Bass that a victim's character may not be proved by evidence of specific acts. And so, and here the dissent held that this court's opinion in Bass would prevent it from showing that the victim was the aggressor. Secondly, the children's statements can't go to support Tom Martin's state of mind. Martins testified that Sarah was not upset when they arrived on August 2nd. There were no problems between there and bedtime, and that there were no arguments between Jason, Molly, and Martins the night before everyone went to bed, and that he had no knowledge and he had never observed physical violence between Jason and his daughter before that night. And that's on transcript page 2734. So it does.
Would they be pertinent to knowledge of Molly Corbett's state of mind? And she also, apparently, as I understood it, relied on self-defense at the trial. So her state of mind would be relevant too, wouldn't it?
Well, her state of mind could be relevant, yes, but there was no aggressor instruction as to Molly Corbett. And the only statement of Molly Corbett that was admitted was the one from the night, the one page on record 430. And she never testified. So there was no evidence for Molly Corbett to corroborate except for her statement about what happened that night. And so the statements of Molly Corbett about things that happened prior to that night that are in her brief are not from any testimony or a statement admitted at trial. Is from an interview that was attached to the pretrial motion in limine.
But wasn't that information considered in the course of deciding whether these statements were admissible?
Yes, it was part of the record before the court, but the decision was, and that was properly considered, or would have been. However, Your Honor, the trial court did not rule at that pretrial hearing. The trial court waited properly to see what evidence came in at trial. And after only defendant Martins testified in a character witness, they made their ruling. So that evidence doesn't come in to show Martin's state of mind. There's nothing to corroborate from Molly Corbett. Her statement that was admitted is just from that night. The long self-serving statement that she gave to law enforcement was never admitted. So, but even putting all that aside, there is no prejudice here because the same factors that undermine the credibility of the children's statements in the eyes of the trial judge would have undermined the effectiveness of those statements to the jury.
Can I ask you to specifically address the issue of the explanation of why the paver was in the room? Because that seems to be this seemed to be based on his own personal knowledge and was relevant to what happened that evening, and seemed to also be important to the jury.
Yes, Your Honor. I'd say that the statement about the paver is somewhat reduced because there was no aggressor instruction relating to that. But Your Honor, that clearly wouldn't be coming in under 803.4. It's not related to any medical treatment. Therefore, it would only be able to pass through and not be barred by the residual exception, which again is abuse of discretion, which this court should not lightly overturn the trial court's ruling on that it was untrustworthy. Now, yes, that is part of what defense argues about the paver, but that is still not the void of reason for the trial court to rule that statement shouldn't come in because of the recantation, Your Honor. But it clearly doesn't come in. It doesn't pass through the 803.4 gateway. I see I'm almost out of time. I'd like to briefly address the bloodstain issue if I can. At trial, the state presented evidence from a bloodstain pattern expert, Mr. James. He testified about the bloodstains on Molly Corbett's pajamas and Tom Martin's boxer shorts.
And before you go any further, Mr. Babb, I've looked. I can't find anything about the pajama bottoms in Judge Collins' dissent. Is there any reference to the pajama bottoms in the portion of Judge Collins' dissent that deals with the blood spatter issue?
No, I do not believe she specifically addresses that. She does state the trial was free of prejudicial error, but she does not specifically address the stains on the pajama bottoms. But of course, they were much less of a focus at trial. It was the boxer shorts because of the hem and stains from underneath. But the important thing I want to try to, two things with this court. First, Judge Collins was correct. It wasn't preserved because they didn't object to the testimony at page 2502. The state did not make this argument below the Court of Appeals, but nevertheless, the defending judge was correct finding it. But even assuming this court finds it wasn't waived, the evidence was properly admitted. Mr. James testified that he considered the stains on the boxer shorts as basically one pattern. Not every single stain on the boxer shorts was tested, and no stains from the inside were tested. And the defendants argue it was highly prejudicial because it showed that that evidence goes to show that Tom Martins was standing above the source of the blood being Jason's head, when he struck him. But the testimony regarding the blood stain on the walls shows a descending succession of impacts. The lowest one was 5 to 16 inches from the ground, and the source of the blood was Jason's head. 5 to 16 inches from the ground is clearly below the hemline of Tom Martins' boxer shorts. And defendant Martins in his brief says the dissents characterizing of the blood spatter evidence as Jason's head being struck as he was descending or near the ground is consistent with his testimony. So the stains on the outside of the boxer shorts show that the wearer was close to the source of the blood, but there can't be any prejudice. First, it wasn't error in 702. The witness testified he considered it one stain and it was reliable. But even if it was somehow, it can't be prejudicial because the evidence already showed that Jason's head was struck below the boxer shorts, lower down. That's both on the wall, shows that clearly, a descending succession of impacts. And so there was no prejudice from that. And the last thing I would say, and I'm sorry, I'm going fast, but I'm looking at the clock there. On the aggressor doctrine, the majority held the undisputed evidence, even in the view in light most favorable to the state, does not support anyone but Jason was the aggressor. That's just not supported by the record. It's contradicted by the record. No physical evidence supports that. And yes, defendants argue, well, you could be strangled and not be injured. And even the state's expert admitted that. And he did say it is being strangled doesn't exclude visible injury, but then what happens a couple of pages later, he does admit, but it's much more common. And so none of this was binding, but the jury gets to make this determination. The defense cites State v. May saying the aggressor aggressively and willingly enters into the fight without legal excuse or provocation. Defendant Martins aggressively and willingly entered into the fight by his own testimony, arguing that he had legal excuse and proper provocation. The physical evidence does not show any injury to defendant Corbett. The jury was instructed on self-defense, as it should have been, and instructed on aggressor, as the evidence supports. If someone grabs a metal baseball bat and enters into a fray, the jury at least gets to, on this record, at least gets to have the opportunity to consider that. It wasn't binding on the jury. It was just an instruction saying it could find that. And that is this court's decision in Muma, while it's plain error, addresses a similar issue. When the physical evidence so strongly refutes what the defendant's story is after the fact, that doesn't bar the jury from considering the physical evidence. I see I'm only down to a minute and a half for the remainder of my time, Your Honor.
Thank you, counsel. We'll hear from the appellee.
Thank you, Mr. Chief Justice, and may it please the court. My name is Doug Kingsbury. I appear this morning on behalf of the appellee, Molly Corbett. Let me begin by trying to respond to some of the early questions about review of the trial court's decision to exclude the children's statements under 8034. Let me suggest that we not lose sight of the core reason why we have that exception. We as adults understand when we go to the doctor that the doctor is there to help us, but the doctor can only help us if we provide truthful answers to the doctor's questions. And I think that really should be the core of what we look at when we're dealing with children who are especially under age 10. Did the children understand that the people there at the Dragonfly House were there to help them? And did they understand that in order to help them, the children had to give truthful answers to the questions that were asked of them? The court's review of that issue is de novo. And I think the record shows that indeed they did understand that. In fact, the testimony was...
Mr. Kingsbury, let me ask you the same question that I asked Mr. Babb a second ago, and I realize this is a kind of question that appellate judges focus on rather than trial counsel for the most part. But according to Hennett, there are really two questions that have to be answered in determining whether there is a hearsay evidence is admissible under the exception for statements for medical treatment diagnosis, and they are: one, did the declarant understand that this was a statement made for medical treatment? And secondly, was it in fact a statement made for purposes of medical treatment? In your view, are those factual inquiries or are they legal determinations?
That's a really important question, Your Honor. And I mean, ultimately, I think the court has to arrive at a legal conclusion, and then but to arrive at that conclusion, it determines what are the facts that help me arrive at that conclusion. I think that's the best answer.
Well, let me hypothetically, I think I posed a variant of this question to Mr. Babb, and since this is, I think, my third stab at it, I'll try to do better than I did the first two times. But assuming for purposes of discussion that we have a finding, however you want to describe it, by the trial court that the children did not understand or did not intend that their statements be used for purposes of medical diagnosis or treatment. Let's just assume that hypothetically. And assume further that finding has sufficient evidentiary support. Does that end the inquiry with respect to the exception for the admission of hearsay for purposes of medical diagnosis and treatment, or is there some other inquiry that needs to be undertaken in addition to that?
Right. I don't think that ends the inquiry at all, Your Honor. In fact, I would go so far as to say is if the children had said, "Oh, we understand this is for medical purposes," I don't necessarily think that wins the day for the proponent of the statement. I really think the key needs to be, did they understand that the reason they were giving this information is the people that were there to help them, and they had to provide truthful answers to those questions. Because if that, and that's the core, if that's not present, then the statement should be admissible. But if it is present, they should be. And if I may say, Your Honor, that's the whole premise of the protocol that's been developed in these child advocacy centers all across North Carolina and frankly all across the country. It's designed to help these children understand that the people are there to help them, but it's critically important that they be truthful in the answers that they give so that the people there can help them.
Is it your contention then that, and I'm somewhat familiar with the way these centers function, is it your contention then that a statement made by a child in the course of the process that's employed by a child advocacy center should essentially be admissible as a general rule?
I think if the protocol is followed and the record is such that the court can be satisfied that the children did understand that they were being asked these questions because the people were trying to help them, and that they understood the importance of being truthful. I think that should be the key. With all due respect, that's my view of it.
Okay.
The state has given a fairly express example of what it feels through Mr. Babb would not be an indication of the children understanding that they need to be truthful for medical purposes. That expression being that Jack, the child, said that It was a concern that this was about custody. He may be taken away. Can the defendant also identify something fairly expressed that would show that the children understood that it was for medical purposes?
I cannot point to anything specifically with respect to medical purposes, but what I can point to is it was clear that questions were being, the children, the questions were being asked about their welfare, about the safety and security of their environment, the safety and security of those in whose custody they currently were living. They certainly understood all that, and all that went to their welfare, which was a part of the basic inquiry there at the Child Advocacy Center. I would also add that, this is a particularly difficult problem when you're talking about issues of mental health, as the court below pointed out. I mean, that's something adults struggle with. They don't always appreciate the medical inquiries that are going on. So I hope I answered your question, Your Honor.
Is that the strongest indication you feel, the fact that this was a mental health diagnosis among other aspects that would qualify for the medical diagnosis prong of Hennon?
I would just add that child welfare, child safety, appropriate custody determinations are all part of what was going on here in terms of the children's physical and mental well-being. And I think the children understood that.
Mr. Kingsbury, can I jump in for a second and ask you, what's your position on the effect of the later recantation?
Yes, that's an important question, Your Honor, and thank you for asking it. As Your Honor knows, the trial court's finding was that the children specifically recanted their statements. That finding is not supported by the record because the children never recanted the fact that their father had these irrational anger control problems. Sarah never recanted what happened that night to cause all of this. Jack never recanted why the paver was in the room that night. So those items were never specifically recanted. But to go further to your question, the first thing I would point out is, these recantations said that the children hated Molly, that she was mean to them, she beat them, she was a child abuser, that she was a psychopath, and that they wanted to see her thrown in jail. Now, those statements directly contradict the trial court's finding of fact number 21, which you will recall. The basis of that was that the children's statements weren't trustworthy because they loved Molly. They wanted her to win the custody battle so that they could stay with her. And it was that finding that was well supported by the record, at least the fact that they loved her and wanted her to win the custody battle. Contrary to the alleged recantations, on the record on page 90, the children wrote notes to Molly at the very end of the custody matter when she lost. Jack says, "Dear Mom, I love you so much, times 999 billion. We will never leave you. You are the greatest mom anyone could ever have. Thank you for being a super mom. I love you past the universe and back." Sarah's note was very similar, and she drew hearts all over it and said, "I hope this makes you smile. Love, Sarah." And in the record, before the children were taken to Ireland, they were allowed to have one final 30-minute session with Molly, and it was captured on videotape. It's in the record. Anyone who watches that and watches these children cuddling and snuggling with their mother for 30 minutes has no real doubt but that they loved her and she loved them. I think that's what the record shows. Now, what happened with the recantations, Jack's video came some almost 10 months after living in Ireland with Jason's relatives, and Sarah's alleged recantations came almost a year and a half after living in Ireland. That's when her first alleged diary entry begins. So what caused this complete 180-degree flip from how much they loved her to now hating her, wanting her to go to prison? Well, I think Jack tells us right at the beginning of his Skype recantation. He says, because I found out what happened to my dad and I want justice to be done. So I think logically, one can assume that people in Ireland, someone in Ireland has told these young folks what they believe really happened to their dad, and it's been upsetting to them, and they want to do something about it.
Because Mr. Kingsbury, I've been struggling with the question that Justice Hudson asked you as well. It seems to me one could argue, well, we've got a statement made by the children at a time when they were in the custody of Molly Corbett's family that's favorable to Molly Corbett. We've got a statement made by the children at the time they were in the custody of the Lynches and had been there for a while that's not. The statements, they may not conflict on specific items of fact, but they certainly have different tones, I think it would be fair to say. Under that set of circumstances, why would a trial court not be acting reasonably by concluding, I don't really know what's trustworthy, because when they are in one condition, they say one thing, when they're in another condition, they say another thing.
I would just say this: the trial court made no specific findings of fact about the allegations in the recantations, but the trial court did make
before I forget it. He did make a statement, or he did make a finding generally about recantation, didn't he?
Just that the statements had been recanted.
Okay, all right, that's okay. That's
all, but not about these details that I've discussed. But the trial court did make a specific finding that the reason that the children's statements were unreliable was because they were motivated they wanted Molly to win custody. They wanted to be with her. Now that is a finding of fact. And these recantations, what I'm saying is, are in direct contrast to that finding of fact. That's all I'm pointing out.
Okay, thank you.
If I may, I want to say something about the prejudice issue in this case, and specifically the impact of the trial court's ruling to keep the children's statements from the jury. The factual issue for the jury was the credibility of Molly's explanation of how this deadly affray began and who was the initial aggressor. The state offered into evidence Molly's explanation, in which she claimed that her husband became angry that night for the seemingly innocuous reason of having been awakened from sleep. And that when she tried to explain why he'd been awakened, his anger escalated to the point of choking her. That she screamed out, which apparently alarmed her father, who grabbed the bat and ran upstairs to the source of his daughter's screams. Now, a rational juror could conclude, okay, if that's your explanation, that your husband choked you because he had been awakened from his sleep at night, well, there had better be some evidence from which I could find that explanation to be credible. And Molly lost her chance to present that evidence when the children were taken to Ireland beyond the subpoena power of the defense. And the trial court denied her request to admit their statements. And the impact of that cannot be overstated. The children were uniquely positioned to know the truth of whether their father had irrational anger problems, and they were in a position to corroborate various points of her statement. Had the statements come in, the jury would have heard from the children that, yes, it's true, our father had irrational anger control problems. And they would have learned from Sarah that one of the things that made him angry was to be awakened from sleep at night, and to find out that their mother had gotten up to tend to the children. They would have learned that what happened that night revolved around little Sarah's bed sheets that had fairies on them and frightened her because she thought they were spiders and lizards. And that she came downstairs, she said very quietly, because you don't want to wake my father up at night. It's a very bad thing because he becomes, quote, very, very angry. And they would have learned that Sarah prevailed upon her mother to get up and come up and change the bed sheets. And of course, they also would have learned about why there was a paver in the room. And we know from the jury foreman that that was the number one question that was on the minds of the jurors when they started deliberations. I know I'm going to get in a little bit here to my co-counsel's time, but I want to say one more thing. You know, we're supposed to look at the existence of corroborating evidence or the absence of it in determining the trustworthiness of the children's statements. We've already pointed out in our briefs that the children's core theme of their father's anger issues was corroborated by Jason's own admissions to his doctor. We pointed out that Sarah's bed sheets were found, and sure enough, they had these little fairies on them. They'd been taken off the bed and were lying next to the bed. I want to point out quickly two things. Number one, the children described at the Dragonfly house that their grandmother had said, look, if anything ever happens, if your father's anger, if there's a bad episode, I want you to call me. And they each had, they said, a code word. Sarah's was Peacock and Jack's was Galaxy. And Jack described that the grandmother's number was written down on the bottom of a toy doll that they had there in the house. And they were just supposed to call the number and say their code word and hang up. Well, we know that statement is true because the police found the doll. Now, the doll itself was not admitted into evidence because without the children's statements, it had no relevance. But what was admitted into evidence was State's Exhibit 149, the police recovered property report, which listed the doll as item number 001. And lastly, little Jack described at the Dragonfly house how sometimes after episodes of abuse, he would find his mother curled up in a ball under the covers. And they asked him, how did that make you feel? And he said, it made me feel sad and angry. Well, the morning that this happened, when the EMTs had finished with Jason and they went to find Molly to see if she needed attention, they testified that they found her lying on the ground, curled up in the fetal position with a blanket. Now, I submit that there is no way young Jack would have known that the EMTs that morning would find their mother in the exact same position that he often found her after episodes of serious abuse. That, in the shortness of time, I'm going to stop there, but the record contains much evidence to support the trustworthiness of the children's statements. So before I sit down, let me just close with this. There is a very real possibility that Jason Corbett initiated this deadly affray, just as Molly reported, and therein lies the problem with excluding the children's statements. Not only was Molly prevented from presenting her defense, we kept from the jury evidence that was material and important to its fulfilling its role as the finder of facts. If Your Honor, please, the Court of Appeals decision was well reasoned and they committed no error of law. I urge you to affirm.
Thank you, Mr. Chief Justice, and may it please the court. Mr. Kingsbury has done an excellent job describing the children's statements, but I do wish to address Judge Irvin's question. Look at the setting of which the children gave the statement initially, talking to DSS workers who are specifically trained to detect individuals who are giving them testimony, and then the Dragonfly House, the Child Advocacy Center, which has a doctor, which has law enforcement, which has social workers, and is separated from any outside involvement, whether it be Molly, whether it be the Corbetts or anybody else. Their statements also proved to be reliable because they were talking about, they didn't know that Jason had been to the doctor 2 weeks before to say that he was stressed and got angry for no reason at all. And they said the exact same thing in their statements to DSS and Dragonfly House. there's inherent reliability, or the paper or the verities on the sheets. There's inherent reliability to what they said, both in the evidence that was developed and in the setting it was given, as opposed to a journal that was not verified. It gave general statements after a year and a half, and in a Skype interview where no specific allegations were recanted, just a general allegation with his aunt and uncle sitting in the other room. The first two statements have inherent reliability based on the evidence and based on the setting with which they were given, and the other two statements don't. We don't even know whether those individuals actually wrote that journal or not. There was no follow-up. There was no setting with which we can determine any reliability there. And if indeed there's any issue to that, that doesn't go to admissibility, that goes to weight. In terms of the blood spatter, Stuart James has written a book on bloodstained pattern analysis. In there, he says, and I quote, "Although it might seem visual identification of a stain as blood would be sufficient to warrant further analysis, proper scientific approach and legal requirements dictate that such identification be established to a scientific certainty before it can be presented in court." Apparently that applies to everybody except for Stuart James. He did not follow his own cautionary warning when not securing the fact that the stained bottom of the hem of Tom and on the bottom of the pajamas worn by Molly were properly tested. And that testimony is extremely important. As the Court of Appeals said, it's the only evidence that allowed James to specifically conclude that Jason's head was near the floor at the time of the impact. The state has argued in the past we can't go test every stain. Well, we're not asking them to test every stain. We're asking them to test all relevant stains. Mr. James had every opportunity before he testified to assure that the key part of his testimony, the testimony the Court of Appeals says was the most probative and most prejudicial, to make sure that bloodstains have been analyzed. He did not.
Mr. Friedman, just one of the things I wanted to ask, and I guess this is probably as good a time as any to do it.
Anytime's good.
Well, not necessarily. I really, off their train of thought too badly. What in your view, is a blood spatter expert required to do in the way of ensuring that confirmatory testing has been done to establish that what he or she is looking at is in fact blood? Are they required to test everything, or how do you?
They're required to test the pertinent evidence, and they're required to test any evidence that is as probative as the Court of Appeals said it was.
So are you suggesting then that anything that the witness intends to testify about at trial needs to be the subject of confirmatory testing?
I would say so, yes.
Okay. Well, I'm just trying to understand the argument.
Presumptive, confirmatory, or DNA testing, which is what is required under Rule 702A. And he didn't do any of those things. It would have been so easy for him to do it. All he had to do was look at FBI agent Wendell Ivory's report, determine those testing had not been done. I mean, when you look at his report, the first two in a supplementary report that we properly objected to, the first two conclusions are the conclusions about Tom's underwear hem and Molly's pajama pants. The first two things he points to are those things. He could have at least, but according to Stuart James, he can't testify. According to his cautionary warning, he can't testify to anything until he's done the proper scientific testing, until he's taken, as 702A3 talks about, the principles and methods and reliably apply that to the facts of the case. He can't do that. Otherwise, he's much like the self-defense expert in the McGrady case, where all he's doing is offering mere conjecture. And he's in no better position than the jury to offer the origin of those stains. And those stains came from a different source, a different blow, according to his testimony, than the stains were on the front of the underwear that was properly tested. He didn't know, he didn't find out, real prejudice, he didn't find out until the day before that testimony was given that that was not properly tested. And did he even take any steps then to do a presumptive or confirmatory test the day before? He did none. He did not. So I would say, according to Stuart James, all those tests have to occur before he's allowed to testify to that. Because if the court doesn't hold that, if the court doesn't hold that expert to that standard, then the gatekeeper requirement that has now been adopted through Brady when Rule 702A was amended and Daubert became the law of North Carolina, then any expert at any time can say, just make things up on the spot. And it's up to y'all, up to the trial court and up to the appellate court to maintain the gatekeeper analysis.
Can you just say a little bit more about the prejudice question? I'm just trying to understand your response to the state's argument that even without that evidence, the blood stain on the wall and the descending pattern was enough to come to the exact same conclusion.
It was not. The state used the evidence under the hem and the pajama pants, which is why it was so crucial to them, to say that Tom and Molly were above Jason when a blow was struck. And that's the only evidence to show that, as the Court of Appeals said. The descending blows show that there was still a struggle going on during the course of the interaction, which is completely consistent with what Tom Martins had said. Tom Martins said he stopped striking once the threat was over, once Jason was down. And the descending blows, any descending blow would be consistent with what Tom had to say. And while not saying it's inconsistent with what Tom had to say, it is something the state utilized to try to impeach Tom's testimony, which obviously was extremely crucial in this case. So it comes from a different source, a different blow, and the state has argued that it's inconsistent. Does that answer your question?
Would you address the same question with respect to the pajama bottoms? I've heard you talk about
the same thing, and that's the other issue about Mr. James's testimony. He said he wasn't, in order to properly testify, he said he has to be provided photographs. Well, he wasn't provided a photograph of Tom in his underwear or the hem laid on the underwear, and he wasn't provided with a photograph about how the pajama bottoms fit Molly on the bottom of where her feet were. And the angle of the pajama bottom, first of all, I'd say he's not qualified to testify because he didn't view the photograph and couldn't tell where the photograph was and how the pajama bottoms were on Molly at the time. And again, it would be the same thing for Molly, that without testing that, you can't determine that's blood spatter. Without determining that's blood spatter.
In the interest of time, let's talk about the prejudice associated with the pajama bottoms separate and apart from the prejudice associated with the boxer shorts.
It's the exact same thing. I mean, it puts Molly in the position of her being sort of over the head of Jason when a blow is struck. And again, it's prejudicial. It's something y'all noticed in McGrady is that testimony from an expert can be both powerful and quite misleading. So when you have an expert who testifies something he has not properly tested and hasn't looked at the photograph, he can't draw conclusions as to the angle of where Jason's head was, where in relation to Molly. So it's just as prejudicial. And I don't know that there's an issue with the waiver, but I wanted to make sure you understand. The state didn't argue waiver at the lower court. On page 2448, we objected to his qualifications. On page 2459, we objected to supplementary report. On page 2462, we objected to Tom's photograph. On 2471, we objected to Molly's photograph. And even though we didn't need to object again on page 2500, we object when he received the specific questions about the opinion. Rule 103A just says once the court has made a definitive ruling about evidence, you don't need to object again. Once we objected to the report, that properly secures that. And that's why the state, I would contend, did not argue that in their brief before the Court of Appeals. I see that I'm out of time. I would just ask that you affirm the Court of Appeals opinion and grant a new trial.
Thank you, Mr. Friedman, Mr. Kingsbury. Rebuttal?
Yes, sir, Your Honor. I'll want to cover just 2 points in rebuttal. First off, on the bloodstained evidence, we're a far cry from Mr. James just making things up on the spot. The majority below the Court of Appeals found that he was unquestionably an expert that was qualified to provide expert testimony. That the stains on the boxer shorts were tested, but only the stains on the outside. Mr. James said it was all one pattern. But even putting that aside, defendant's position is that was the only evidence. That's the argument that was just made. That's the only evidence, the pajama bottoms and the boxer shorts interior stains of them being above Jason. But I'd submit the bloodstain evidence on the wall shows a descending series of impacts, which counsel admits is consistent with Martin's testimony. The lowest one is 5 to 16 inches above the floor. Unless defendant Martins is laying down beside him, which he didn't testify, and swinging the bat that way, he has to be above him because the evidence on the outside shows he's close to the source of the blood. There's no other reasonable explanation for the jury to infer. And then as regards to the children's, I'm running out of time, but as regards to the children's statement, Justice Ervin, I would suggest your question answers itself, and that the statement was not reliable, and the great contrast shows that the trial court made the right decision. I'm out of time, Your Honors, unless you have any other questions. I ask you to reverse the Court of Appeals.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is in recess. God save the state and this honorable court.